That's good. Hi, welcome to Law and Liquor with James, where the legal talk is as smooth as a Macallan 18. And the more I talk, the less you understand. What did I say? Take two. The more I drink, the less you understand. Today's topic, Palsgraf. Today's episode is brought to you by Redbreast Lustau, courtesy of a recommendation from my friend in law school, Chris Wheaton. And today's topic is also recommended by Chris Wheaton, and we're going to be talking about Palsgraf versus Long Island Railroad, which if you are a law student or a lawyer, you probably hate this case, but you probably love it too. So let's get into it. So, holy shit. Okay. Too much Lustau. All right, so Palsgraf versus Long Island, jeez, I can't say this right. Palsgraf versus Long Island Railroad is a fundamental case in American jurisprudence that every law student has to learn, and that whether you know it or not, it has fundamentally shaped the world around us because of its holding. Let me set the scene for you guys, okay? So we're back in like 1920s or whatever the heck. Poor Mrs. Palsgraf is catching a train. She's going on a nice little vacation. And of course, she doesn't have a car and no airplanes, none of that stuff. So guess where you go when you want to go on vacation? You got to go to a train station. So she's at the train station. The Long Island Railroad Company owns this train station. And as you might have guessed, it's in New York. And so she's standing there. She's waiting for her train. And just above her are these scales, right? These like industrial scales where they weigh things to get on the train and things like that. And she's just kind of standing there waiting for her train, and a train is departing the station. All right, so you visualize Mrs. Palsgraf with her little, maybe her purse or her bag or her suitcase or whatever, and she's waiting for her train. The train is leaving the station, and these two guys start running to catch the train, and they're, don't stop, wait. And you've seen this scene hundreds of times, right? If there were somebody is running to try to catch the train. So there were two workers with the Long Island Railroad, and one was on the train, and they were kind of coaxing the two gentlemen along, like, come on, and one was on the platform trying to help them onto the train. Well, the first guy got on the train perfectly fine. Everything was great. The second guy, he had a parcel of something. Nobody knows what it was. Well, we know what it was, but at the time, nobody knew what it was. It had a parcel of something wrapped up in newspaper. It was unassuming, not threatening, kind of small. The one railway worker grabs the gentleman to hoist him onto the train, while the other railway worker is trying to push him onto the train from the platform. And so as he pushes him onto the train from the platform, the parcel in his hands that he's got falls down on the tracks, gets run over by the train, and unbeknownst to anybody, it was a parcel filled with fireworks. Boom! So the fireworks go off, and the percussion from the fireworks, if you can imagine, you remember that, boom! And it kind of rattles the house and all that. That percussion was enough to knock or move the scales above Mrs. Palsgraf's head, and the scales toppled upon her, and she was injured. So naturally, what do you do when you're injured in this country? You sue. That's just what you do. You sue. My wife says this all the time. She always says, can they do that? Can they sue for that? And my answer is always like, yeah, they can sue for anything. Anybody can sue for anything. The question is do you actually have a case? Do you have a actionable case? Do you have a case that can win? And if you are bringing a case for like personal injury or some sort of civil wrong, not a criminal wrong, but a civil wrong that's been done to you, more than likely this case is really what's going to be governing whether or not you win. And so what happened in this case was Mrs. Palsgraf sued the Long Island Railroad Company for negligence. Now negligence is it's a class of civil tort liability that basically says if you've done something not intentionally wrong to me, but you've done something where you should have known that I would have gotten hurt, then I can sue you for my damages, right? Think of you were running too fast and you tripped and you ran into somebody. Okay, well that's negligence, right? You've caused a harm to somebody that was unintentional, but because of what you did, you caused harm and now you should pay damages. That's what Mrs. Palsgraf was arguing about the Long Island Railroad. She was saying that, hey, your employees helped these two dudes onto the train after it was already moving, and because of that, it caused the parcel in their hand to fall, which caused the fireworks to go off, which caused the scales to fall, which fell upon me, and now I'm hurt, so you should pay me. And the opinion in this case was written by a really famous judge named Judge Cardozo. Even if you're not a lawyer, if you could just Google Judge Cardozo, New York, and just read some of his opinions, they are, I wouldn't want to say hilarious, but they're just written so well and almost poetic. So, you know, and maybe this is just me nerding out on elements of law that don't really matter, but go and read a Judge Cardozo opinion. It's kind of fun. Anyway, Judge Cardozo said, wait a minute here. Wait a minute. The Long Island Railroad didn't owe a duty to Miss Palsgraf to prevent the scales from falling on her. The Long Island Railroad owed a duty to these guys getting on the train. That's who they were owed a duty to, right? Because negligence is premised on the fact that I have a duty to you to act like a, what's called like an RPP, that's shorthand in law school for a reasonably prudent person. We all have an obligation to each other to act as a reasonably prudent person in our activities. Baseline duty to everyone. And so the baseline duty to the Long Island Railroad was you had to act as a reasonably prudent person to these two guys coming on the train. And because this parcel wasn't marked dangerous, because it didn't say fireworks on it, and because it was relatively unassuming, the workers for the Long Island Railroad, let's say that again, the Long Island Railroad had no idea what could have happened. In other words, what Cardozo says is they couldn't foresee that there were fireworks in there, and therefore they couldn't foresee that the fireworks would fall and then go off in the manner that they did. So really, what this does is set the stage for whether or not we're liable to other people for our conduct. And so this whole case kind of outlines what's modernly known as proximate cause. So in order to be liable for negligence, you have to have a duty to someone, you had to breach that duty has to cause damages, and it also has to be the proximate cause of those damages. So it's not enough that, for example, they had a duty to Mrs. Palsgraf, it's not enough that she was damaged, and it's not enough that the fireworks caused the scales to fall. The issue in the case is, was it the legal cause? Was it the proximate cause of her injuries? In other words, was it part of the class of injuries that Long Island Railroad was obligated or had a duty to prevent or protect Miss Palsgraf from? And Judge Cardozo in that case says no, because it wasn't foreseeable. It just was not foreseeable at all that this package that was not marked dangerous, was not marked fireworks, would have caused the type of injury that it did. And so now we have in sort of modern jurisprudence this idea of proximate cause, and it's been litigated over and over in the courts in the nearly 100 years since the decision, or maybe over 100 years since the decision. I'll have to go back and check the date. And it really has set the stage for, you know, things like the McDonald's case, right? Can McDonald's foresee that it's really hot coffee will boil someone's skin? And so everybody's, you know, all these sort of, say like cult classic type cases, the McDonald's case, the burglar falling through the skylight and cutting himself and suing the homeowner, that kind of thing, are all these things, right? The question really comes down to is this injury by someone reasonably foreseeable so that the person who could have prevented it should have prevented it? And if the answer is yes, then they're liable for the damages. Incidentally, when I used to do personal injury law, the issue of proximate causation and the issue of duty, because it's really a question of, does the Long Island Railroad have a duty to Mrs. Palsgraf? Because you have a duty to present foreseeable injuries. And the issue in that case was it wasn't foreseeable. So there's a huge thing, at least in California right now, with baseball parks. Generally, when you attend like a baseball game, you basically, there's this doctrine called the assumption of the risk. Everybody is said to have assumed the risks that are inherent in the activities that you're going to. So baseball parks, for example, don't necessarily have to prevent foul balls from going behind you, and for baseball bats entering the stadium. So when you get injured by a foul ball or a baseball bat, you know, the ballpark is said to say, we don't have a duty to you. We're not obligated to pay for those because you have assumed that risk of injury. Well, there was a case, 2 years ago out of the California Supreme Court that kind of tweaked that rule a little bit. And so at least in California, we're seeing a little bit of an eroding away of some of those duty proximate cause kind of analyses, just because things are a little bit different than they were maybe hundreds of years ago. For example, in the baseball case in California, which involved the Rancho Cucamonga Quakes, which if you could zoom all the way out there, you could see their stadium right through that window. But we don't have a zoom lens like that, so just trust me. It's there. The analysis there for the court was, listen, yeah, they assume the risk of injury, but there's all sorts of things that baseball parks do voluntarily to prevent these kinds of injuries, like putting up foul ball nets. And where the baseball park voluntarily constructs these types of barriers, it now takes on a duty to prevent those injuries. And so that's kind of the analysis where things have changed. So, Palsgraf, that would be if the railroad had taken on the duty to protect or sort of secure its sort of rigging against percussive explosions, then they might have had like a duty again owed to Mrs. Palsgraf, because they at least could foresee or at least anticipated some sort of damage occurring from percussive explosions, even if they couldn't anticipate that particular package being, the type of package it was. So that's Palsgraf. It's a fun case. It is literally about 3 pages. Do you have it? Can you get back to me, Claudia? It's like 3 pages. It's actually 12 pages, but most of it's the dissent, which is kind of fun to read. Just like simple pages, big old words, simple pages, written by Judge Cardozo, real famous judge. Read it and understand knowledge. And that is Palsgraf. Cheers. Ooh, yeah. Like a firework in my mouth. I love you, Palsgraf.